My name is Ann Del Castillo, and I'm the Senior Policy Officer here at the Department of Cultural Affairs. I want to thank all of you for attending this second installment of the NYC Create and Place Legal 101 series. Today's focus is on creative spaces and commercial leases. Before we officially kick off, I just want to address some of the general housekeeping items. It sounds like you can hear me, so we've taken care of that. If any of the presenters are speaking too fast or too slowly, just let us know through the chat. And then do know that there's automated closed captioning available for those who wish to use it. Video is enabled for speakers and panelists only. Participant mics will be muted throughout the webinar, and the raise hand feature will be disabled. So we're asking that you submit your questions through the Q&A feature. We'll begin the session with just a few opening remarks and then the presentation from the panel. And then after the presentation, we'll kick off the Q&A. Do know that this event will be recorded and posted on the Cultural Affairs YouTube channel, as well as the NYC Create and Place Resource Hub. And now it is my pleasure to introduce our presenting partner for today's session, Patricia Wong, Program Associate of Pro Bono Programs at New York Lawyers for the Public Interest.
Thank you so much, Anne. Good morning, everyone, and thank you all for joining us. As mentioned, my name is Patricia. I'm the Program Associate for the Pro Bono Clearinghouse at New York Lawyers for Public Interest. The Clearinghouse is committed to strengthening the nonprofit sector by providing resources, building capacity, connecting nonprofit leaders to pro bono legal assistance. Due to this partnership, we've developed with our valued partner law firms, we're able to connect nonprofits with legal assistance on a range of issues, such as lease reviews, corporate governance, and intellectual property concerns. So feel free to reach out to New York Lawyers for Public Interest for any legal needs for your nonprofit organization on today's topic or any other legal topics. And I believe Anne will be sharing our contact information in the chat shortly. For today, we're excited to be bringing you a presentation on leasing fundamentals as part of the Department of Cultural Affairs Create and Place program. We're so appreciative to Anne and the department for inviting us to partner on this series. We also want to extend our gratitude to Morrison Foerster for their longstanding support of New York Lawyers for Public Interest and the nonprofits in the New York City area. And with that, we will also like to offer our sincere thanks to Mark Edelstein, Jeff Temple, and Alfred Williams for leading today's presentation and offering their years of experience and expertise on this topic. With that, I will turn it over to Mark to introduce the team officially and start the presentation. Thank you.
Thanks, Patricia. Mark Edelstein. Our law firm is Morrison Foerster, lovingly known in our industry as mofo.com. You can't beat it. We're going to cover creative spaces and leases. For us, this is kind of fun to do this slightly different angle than what we do mostly every day. My partners are Jeff Temple and Al Williams. I'm going to make a very quick introductory remark and then turn it over to Al. Al, if you jump to page 1 quickly, I'll run through that in 30 seconds. So what we're going to cover today is a high-level focus on tenant-side negotiations. And basically the core provisions in a lease. We're going to talk about the premises, the space that you're going to lease, common areas important to your business, the term, meaning how long out the lease goes and whether there are extension options, the rent, and we're going to talk about what you pay and what you don't pay, and tricks that we don't want you to fall into, or traps when you negotiate a lease, maintenance of the space, assignment and subletting if you want to get out of some of the space, and subordination, which Al will explain to later. There's some more complicated topics that we're not going to cover, like condemnation and purchase options. But I think if we can get some points across on what we are going to cover, it'd be really invaluable to everybody on the phone call. So Al, I will turn it over to you and we'll get going.
Hi, everyone. Thanks for having us here today. And Mark, thanks for the introductory remarks. We thought it would make sense and be helpful to just start with some sort of general considerations as you move towards negotiating your lease with a potential landlord. And I think throughout the presentation, we're gonna try to keep it to as much practical advice as we can offer you. You know, the materials outline some of more of the substance of it. And at the end of the presentation, we'll share these with you all. But if we don't get through it all, we thought it would be more helpful for you to hear sort of some of our tricks and whatnot that we've learned over the years. And Mark and Jeff will be jumping in as they have thoughts about those along the way. So with that, the first step, once you've identified a potential space, is to really focus on negotiating a good letter of intent with your landlord, or LOI. This is much like a term sheet that you might enter into if you're doing a business deal. And it really sets forth the terms that are most important to you. And although these are legally non-binding for the most part, I personally think that they are arguably the most valuable document in the entire transaction. And the reason for that is because when it comes time to move towards a formal lease document, your landlord and their lawyer are going to produce the first draft, and they're going to use their standard form. And if, especially as a, 501c3 type of tenant, who's not paying all the money in the world in rent and may or may not have the strongest relative, bargaining power, they're probably going to tell you on a lot of points, hey, this is our form lease, we don't negotiate this. But the one thing that we can always point to is, hey, we agreed to this in the LOI, it's right here, this is a very important point for us, and that's why we set it out in this early stage, and so therefore we really need it reflected in the lease. So, to that point, although lawyers aren't always involved at the LOI stage, and oftentimes brokers may just sort of try to encourage the parties to move through that phase as quickly as possible, we do recommend, and understanding it's always a bit of a cost balance act in terms of how much you use your lawyers, try to get them involved as early as possible. We can definitely help you at the LOI stage. And we can make sure that things are clear. We can help come up with a list of what should be included. And it's much easier to be able to have that stuff outlined at the outset than it is to try to ask for it later.
Al, can I
Yeah,
jump in
Yeah.
and offer supplement what you had talked about?
Mhm.
So I guess a couple of random thoughts to elaborate or supplement on that. First, I think very importantly, note that getting a broker involved, if it makes sense, is a great move, in part because while you can identify and work with a broker to help you find space, the broker will be compensated by the landlord. So effectively, by getting a broker involved, if it makes sense, you can do so, but not expect to have to pay that broker, because the broker is compensated the time that the lease is signed by the landlord. So they're sort of a free source of professional support, if you will, not only to identify the right space for your business or endeavor, but they can help guide you, give you good market perspective. The landlord who you're potentially dealing with is going to say, I'm willing to lease you this space for X dollars. The broker can help you evaluate and identify whether the financial terms being offered are, quote, market or not. So they can be a great resource. And tying that to the LOI or letter of intent stage that Al was talking about, which I totally agree is a critical part of the transaction and ultimately the transaction documentation. Good brokers will get very involved in working with you as the ultimate tenant and client in drafting and negotiating the LOI, and they will also work side by side with the lawyers involved in that, so they can be quite a helpful resource. There's no reason you have to. How this unfolds for each and every one of you listening in is going to be different. Maybe you want to open a dance studio in Brooklyn or a small theater in Lower Manhattan or whatever it may be, and you may know that area or know that neighborhood where you want to be and go around and identify a space and you're able to find on your own who the owner of that space and the landlord is. So you can theoretically do that without a broker. But if you have sort of a broad mandate of saying, I need this much space in this area, this is my budget, and I really am not sure where that desirable space might be, identifying and finding a broker, they're the people who can help you find the right space, and they're the people who can help you negotiate the best and the fairest financial deal to get you what you're looking for.
The only thing I would just add is very, very important if you do bring in a broker, really educate them on your business. There are a lot of people on the phone and there are a lot of potential businesses here. So the broker understands what the layout is, what you need to do in order to move forward, whether it's art or dance or recording studio, so that they know when they go to the landlord, when the landlord is like making an offer or putting his numbers on the table, he knows exactly what you want, so that you're not surprised later when you come back and say, well, we need seating or we need specialized equipment. And then the landlord comes back and says, well, that's going to cost more. So make sure that the broker knows exactly what you're going to be using the space for.
Yeah, and Mark, that point is actually something we'll come back to in many instances throughout this presentation. Helping your landlord understand how your business operates is a very useful negotiating tool when it comes to asking for certain things, because ultimately, negotiate. If the landlord understands that you need what you're asking for and how that sort of works within your business, they're probably going to be more likely to have that conversation with you. It's a really important point to keep in mind generally as well. I just want to quickly touch on engaging counsel before we move off the slide. I think it's worth mentioning, especially for nonprofit organizations, in hiring counsel, it can be, there are always concerns about expenses that are being incurred when you're doing transactions like this, and maybe you have a friend or family or someone who is willing to help you out, and they're a lawyer and this and that. I think it's just really important to keep in mind that leasing within New York City, just like a lot of other areas of the law, is a very specialized and local practice, meaning not only are there local laws that you need to be aware of and understand, but also sort of the points that get negotiated and sort of don't get negotiated, and what you can kind of expect the landlord to agree to or not. That's all. There's sort of this community of leasing practitioners that knows and understands that and will help you be able to navigate that process based on their professional experience much more efficiently. So even if somebody offers to help you and it seems like it may end up costing the company less money, it may actually end up either costing you more in legal fees or in other costs that the process drags out and it's not a efficient and productive negotiation because counsel just is sort of not the right type, doesn't have the right type of experience to lead that process.
Yeah, why don't you jump to page 3? And I just noticed that the top of page 3 has some of what we were talking about, specialized needs. So, these are just a few examples when we say, educate the broker, but we also need to educate the landlord. Are there any specific unique uses for the property? Do you need parking? Do you need overnight parking visitors? Do you need any trade fixtures or large systems to be installed? Will you have equipment that needs to be financed? The landlord's going to need to know hours, ingress, egress, how people get in. Or is it a performing arts thing where people come in for 2 hours then leave? Is it an art gallery where people can be wandering in and out all the time? And also the hours are important because a lot of landlords might charge like extra fees for after hours, or they need to spend union wages to keep space open late at night. So all those things are things to think about. A lot of the creative spaces, people are going to walk in with their dogs, right, or their pets, and some landlords might say that's not allowed under the lease. So these are the sorts of things you need to sort of educate the broker and the landlord on.
Yep, totally agreed. Jeff, I'm going to jump to the next slide because I've touched on a lot of this, unless you had anything you wanted to add.
Well, yeah, just only to slightly elaborate on Mark's comment and to be maybe even a little bit more specific. based on my sense of, our audience and your needs and uses of the space, I would say in particular, if you're looking for space that will involve, once the space is open, a lot of foot traffic and, for example, access to the public. I'll use a made up example of again a dance studio, and you have people coming in to go to dance classes, or if it's a performance type venue that you're looking to lease, and you're going to be literally inviting members of the public to view presentations and performances. That's quite important to get out there very early on with the landlord. Landlords want to know who's going to be in the space, who's going to be using the space, how many people are going to be using the space. You want to make sure as a tenant that the landlord isn't going to try to limit or block access to the space. So again, there just needs to be an open understanding and discussion of the nature and scope of your use and the visitors to the space. And we need to make sure as a business and legal matter that the lease document clearly identifies that and explains both what your so-called permitted use is, and doesn't impose any restrictions on your ability to have that type of foot traffic and visits and things like that you expect and need as part of what you're trying to do in the space.
Yeah. An example might be if you expect at a peak time 100 people to be in your space, then find out from the landlord that the space has a certificate of occupancy for no more than 50 at a time. That's going to be something you need to know about, and the landlord's going to need to know about your needs.
Okay. So on the next slide, I just wanted to quickly touch on the parties to the document, because you're going to get this draft lease from the landlord and their counsel, and probably going to take a look and see an entity on there that you don't recognize and isn't the same name as the company you've been negotiating with. And we just wanted to point out and make sure everyone understood that this is very common. Most landlords in New York City probably own each individual building through its own separate LLC. And if they have a mortgage on the building, that may even be required by the mortgage lender for reasons that are beyond the scope of this presentation. So just sort of as a practical piece of advice, that's nothing to be concerned about. It's not worth discussing with them. It's not a trick that they're trying to pull to protect themselves from obligations that they owe to you. It's perfectly ordinary course and nothing to be concerned about. On the flip side, as to whether you as the tenant should also have your own sort of separate LLC to enter into the lease, at the end of the day, we often see companies sign these leases, companies like yours sign these leases directly themselves. It would be perfectly ordinary for you to do so. If you do decide that you want to create a separate LLC and try to, isolate any potential liability under that lease to that particular entity, just be aware that your landlord is probably going to expect that you deliver a guarantee from the company or the individual behind the company anyway. So, some of the protections that may be afforded through that will maybe end up kind of becoming obsolete as a result of those guarantees anyway. So just, again, a practical sort of piece of advice when it comes to thinking about what entities are going to be party to the document.
Yep. Hey, let me jump in. This is an example of something you said that I think we're going to cover later on in the presentation when we talk about monetary considerations, but your comments made me think of this and want to highlight it for the audience. So frankly, a critical part of the process of leasing space will be, once you found what you think is the right space and you negotiated the financial and business deal, the landlord themselves is going to be looking quite closely at you who you are, your business, the nature of the business, and then they're going to look at your financials, if you will, for lack of a better word, your history, your business operation. And I believe that many here participating in this are going to be not-for-profits, 501c3 companies, and perhaps organizations that are early on in sort of their lifespan. You just need to be aware of that the landlord itself is going to make its own sort of assessment. They may be asking you for financial statements, as Al said, depending on who your legal entity is that would sign the lease. They may ask for a guarantee. And again, we'll talk about this later. But it is also very likely that they may ask for, as part of the lease transaction, a security deposit, which we'll explain in a little bit of detail later, what that is, how it works, the amount that it may be, and when you get that back. But I just wanted to highlight that sort of early on in the transaction is typically when the landlord will want to know more about your business, your financial wherewithal, because the landlord themselves, will want to know that they're picking the right tenant for their space.
Right. And your job, obviously, as tenant, is to try to limit any personal liability whatsoever. If excuse me, if you're asked for a security deposit, obviously, and you agree to the amount, try to limit, to the extent you can, any further recourse down the road if things don't work out, to keeping the security deposit, but nothing more.
So the next series of slides, we'll start to get into the negotiation around and getting the demised premises ready for you. And so I think the way to think about it is, as a starting point, you are getting the space as is, where is, with all faults, which means, the landlord, it shows you, the broker or whoever shows you the space, and kind of this is what you're getting. Now, it's not uncommon for, as part of these preliminary discussions that we've been sort of emphasizing, big point that we've been emphasizing, as you explain to the landlord sort of how your business operates and what your needs will be, to negotiate sort of a package to get the space ready for you and your business specifically, and sort of who performs that work and who pays for that work is often just a matter of negotiation and driven by what is market at the time and how bad you want the space and how bad the landlord wants you in there. But many times the landlord will do some form of build out for you, which means before they turn the space over to you, they go in there with their contractors and they get things ready. It may not be specific work to your business, but it may, it will reflect what you've discussed and agreed upon up front. And then, when they're done, they'll turn the space over to you. And there may be a period of time at that point that you've negotiated and agreed upon where you'll have the ability to perform your own work, bring in your own contractors, and get the space even more ready for your specific use. And again, it's always a matter of negotiation, but sometimes, landlords will offer economic incentives, including, an allowance that helps pay for some of the work that you would be doing. A free rent period during which you're performing that work because you're not really operating. One thing, regardless of whether or not you're getting any incentives, that's always sort of important and helpful to address up front, is, hey, this is what I want to do with the space. These are the contractors that I want to use. These are the plans that we've had drawn up. The more of that you can get agreed upon upfront, preferably at the LOI stage, the easier it will be to work your way through that negotiation at the lease stage, where you'll have much less bargaining leverage with your landlord. You may find that they want to charge you fees and have approval rights over things that you sort of thought were just things you were going to handle. And a lot of that are things that you can address, in the LOI and have agreed upon and pre-approved up front.
And one little tip, I don't know where it fits into this page, but you're going to do a walkthrough. You really want to inspect the space before you move in. And if you do move forward with the LOI or lease, you might want to take out your iPhone or your Android and video the space, because one of the requirements of most leases is that at the end of your lease term, you have to give the landlord back the space in the condition it was before. And also remember, there's a security deposit there. And very often landlords will say, well, this is broken, that's not working, you caused damage, and they want to hold some of the money. But if you could show that that was the nature of the space before you moved in, they'll give you the money back. So it is very important to keep that as a record, just that practical advice.
The only other thing I was going to say on this slide, and then I'll give Jeff a minute to jump in with his thoughts as well, is just to point out that there is always a section of the lease that deals with alterations or changes work you may do to the space during the term of the lease. This is typically different than your initial fit out work or getting that space ready for your initial occupancy. Alterations are often going to require your landlord's approval. They're going to want to see what you're doing. They're going to want to know who's doing the work. They may want to hold security. It's just important when you're negotiating the lease to make sure that the language is very clear that that initial work that you agreed upon to have done to get your space ready for you to move in is sort of not part of that same approval right and process and is dealt with separately.
Yeah, Al, the only thing I might add on this topic generally and addressing it to, again, the specifics of our audience here, I think it's highly unlikely for those of you here with us that are looking to potentially lease space that you're gonna find a space that is exactly set up day one when you see it that meets your needs, like a so-called vanilla box. If we were talking to a group that was focused more on leasing a small suite of offices somewhere in New York City, that vanilla box might apply, where that can easily be found. Landlords, the term is pre-built space, and they say, here it is. We set this up. It's nice and clean. Go ahead and occupy it. We're just giving it to you. But I think given the nature of your businesses and endeavors relating, to the arts and creative endeavors, you're going to find a space that invariably is going to need some work and need some improvement, either by you and or by the landlord. And the other thing I would point out, just by way of sort of just general advice, recognizing who all of you are, to the extent that you yourselves don't have experience with, and as a lawyer, as an example, I'll use myself. I don't have experience with going into and looking at a potential space and looking at what is the condition? Is it does it have everything to fit my needs? Does it have the proper electrical capacity for my needs? Things like that. So to the extent that you have someone on your team or even a friend or whomever who has some experience with, construction and more technical matters that can come with you to sort of evaluate the space and look at it and say, well, how might we need to fix, build, or adopt this space for your intended use? That's really important. And as Al said, identifying that and negotiating that with the landlord as to who is going to make those improvements, make those fixes, build out the space, and who's going to pay for it is frankly a critical part of the transaction terms. And you don't want to commit to any space before you know what work is going to be needed to make it ready for your use and how much is it going to cost.
Okay. We covered quite a bit in terms of getting the space ready. So I'm going to jump down next to permitted uses. This is a section in your lease, and I really just wanted to make one point on that. Yeah, this is a section that is easy to overlook, but is important to read carefully. Sometimes there's a lot of what appears to be boilerplate language, and what is boilerplate language that the landlord's lawyer may just leave in the form. But it's important to read through all of that and make sure that none of the prohibited uses or things that you may end up needing to do as part of the ordinary course of your business, or even from time to time. The devil's in the details a little bit here. And from a practical standpoint, this may never come up, or you may end up finding as time goes on that you have a difficult landlord that lives by the letter of the contract, and they end up giving you a hard time over things based on what the lease says, even though that's just how your business has always sort of operated. So this is a section of the lease I would just say, even if, when you're working with counsel, even as sort of the business person involved, you should still sort of take your own read of that and just make sure that there's nothing listed in there that you could see yourselves actually needing to be able to do. So on the next page, landlord relocation rights. Some landlords will sometimes have these in leases. It's something to watch out for. You may or may not care. It's important to make sure that if they do have this right, the spaces, of equal or greater quality, the location will still work for the permitted uses. It's not going to change your rent. If there were any important characteristics about the space that you sort of focused on up front, like maybe this amazing natural light that comes through the space, that those sort of characteristics would not be lost if the landlord were to exercise these rights. So, something to be wary of in general, but if it is something that your landlord sort of insists on needing, just make sure that it gets carefully negotiated to make sure that you can't end up in a worse position than you bargained for to begin with.
And this is a bit of a tangent, but it's worth an example. Try to get a sense from, you're looking at the space the moment you're there and you're saying, this might work for my business. Try to find out if the landlord has any plan to construct or do anything to the building or streets around the building. We had a project with like a Walgreens in Greenwich Village, and they moved in, and then within a month or two, scaffolding went up to rebrick the building under a local law which requires inspection of buildings, and the scaffolding hung in front of the store for a year and a half, and people were afraid to go under it because there are ladders and workers overhead, and so that was a big negative. So try to find out either through the broker or the landlord, they plan during the course of your lease term any sort of improvements or construction to the building that could affect what you're going to use your space for.
Yeah, Mark, that's a really timely comment too, especially with all of the conversions that are now happening in New York City, right? You may or may not be aware, but there was a big plan that Mayor Adams had recently approved called City of Yes, that allows real estate developers to much more easily convert their buildings to residential use, given the affordable housing crisis in the city. And so the way that the landlords are able to do this is they have clauses in their leases that are often referred to as demolition clauses, that basically the tenant sort of pre-agrees to let the landlord sort of move them around and knock down and change the space that they were originally in. So if you come across something like that, it would usually be a good flag for a discussion point with your landlord to try to understand the bigger picture and what their plan is for the building and how that could affect your operations. The other points on the slide are just about sizing needs. Jeff mentioned early on, companies, you may be at different stages of your life. So, maybe a new startup, you may be around forever and know exactly what your operations look like. But there are different provisions you can have in the space. You may be in growth mode, contraction rights, which would give you a period of time by which you have the right to downsize your space. Rights of first refusal or first offer to expand your space. If something becomes available, you want the first right to expand into that space, at then current market rents, etc. So these are all provisions that you can discuss with your landlord to include based on sort of the life cycle of where your business is at the time and expected to go during the lease term.
And very often, when you're looking at the space, again, we make sure that the lease matches what you're expecting. But sometimes there's basement space for storage or other uses, and you may see that and think you're eligible to use it. If that's the case, make sure it's included in the lease. Or landlord might say, we gave this to another tenant, or if you want that, it's going to cost X dollars more. But just make sure it's clear that any other connected space in the building you think you may need. And again, I mentioned earlier, make sure that there's egress and ingress. Sometimes you could access the space through a hallway of a lobby of a building, and sometimes it's street frontage. Maybe it's both. Just make it clear, because there might be restrictions of people coming into an art gallery through a lobby of, say, a building, an apartment building. So just make sure you know how people are going to get in and out.
Common areas. I think we can kind of go through this quickly. I'll just note a few things here. One being, there are certain common areas in the building that you should expect to be able to use: hallways, elevators, things like that. There are other things. If there's a fitness center in the building or a cafeteria, it would be more customary for you to have to sort of negotiate for the right to use that space, and it may come at a cost. So all things to be mindful of. The other high level mention about common areas, and this gets into a later portion of the presentation on rent and additional rent, is that although landlords are generally responsible for maintaining and paying the cost of maintaining the common areas, it's also customary for landlords to pass through those costs pro rata among the tenants based on the size of your space relative to the overall building. So just something to pay attention to in the lease, and understand that you may not have to do any work in that part of the building, but those costs may still end up getting passed through to you in part as additional rent.
Yeah, and what you pay, how I say this. So we're focusing on what's called rent, or you might hear saying, I'll talk about percentage rent, but there are other pass-throughs really, really important to focus on, so you're not shocked later on, where the landlord might pass through taxes on the building, a percentage to your space, or electrical charges for your space, or insurance. So you really, from the landlord and broker, if you think you're paying X dollars a square foot, it may be a 1.2x or 1.3, because you don't know what those charges might be. So it's really important, even if they won't tell you exactly, tell them how it's calculated. So you know when you go in, you have a sense of what the totality of costs are going to be. You don't want to be surprised later on. You're paying my rent, everything's good, and now I'm getting these charges, and find out not only if you get charged, how often. Sometimes there are adjustments at the end of the year for taxes in the building. You may not know during the course of the year, you may know the following year. So it's important to highlight every possible cost that you might have to pay, so you could figure out if it makes sense for you in your business. So there was a question about storage. Very often storage space within the four corners of what you're leasing is included. Sometimes there's a door in the back or to the basement. But those are the ones I'm most concerned about, because you may think you have access. We've had the tenants see a door into a basement of a building, and it was empty, so they started using it, but they weren't paying for it. And the landlord later found out and basically said, if you want to continue using the space, you're going to have to pay additional rent. So
it's always best if you need storage space and you know that there may be some in the building to identify specifically what you're looking for and to document that in the lease rather than have just sort of a handshake or understanding. And as Mark said, you know, that often can be an option, but you know, landlords look at their building and their space as, you know, there's value there. And so for the most part, you know, if you're leasing certain premises and then there's a basement storage space, they may well be happy to have you use it, but they're going to want to charge you something for it. So it's better to you know, identify that up front and document that in the lease so there's no surprises.
And always ask if there are any overtime charges. Very often you may have you know, you're paying as part of the lease what we call HVAC, heating, ventilation, and air conditioning, and you think that's great, but you might find out when you move in the building, if they heat your space after 6 p.m. or 7 p.m., there'd be a charge. Or if you need an elevator to get your space, it's included. But if the space is needed in the evening, it's after hours, they may charge you union labor just to keep the elevator moving. So always ask if there are any extra charges for anything relating to overtime.
Yeah, and not to scare everyone listening, but we're kind of harping on this, but there really are in leasing generally a myriad of charges, some small, some not so small, that are going to be built into the lease. And you guys, as you know, sometimes first timers, you've never done a lease before, this is the first time you're doing it. Those charges may not be readily identifiable, but again, if you're working with a lawyer, a broker, all of this is going to be set forth in the lease, but you want to make sure you pay attention to that, you understand it. There could be some language in the lease, like Mark gave a good example of passing through overtime charges for utilities and what have you. That may be some general language in there, but it doesn't say exactly how much they're going to charge you. And so if I were working with you and acting as your lawyer, I would say, okay, well, you know, my client, you know, is going to be using the space 3 nights a week until 9 p.m. And I would ask the landlord, give me an estimate of what that's going to cost. So again, you're avoiding surprises later. Better to know what you're getting yourself into.
And this may sound dumb, but if you're working with an architect or even the broker, or even if it's a smaller space, take out a tape measure, actually measure the space. Kind of sounds silly, but you're probably paying rent on a per square foot basis, and landlords in New York are fairly unscrupulous in terms of where they're measuring from. Does it include a bathroom, a closet? Sometimes in commercial spaces, they measure even outside they'll measure into 3 feet into the street, or they'll measure into a hallway and charge you. So you want to make sure you know the rent and you know how much space you're taking.
All right, now why don't we keep going, because there's some important stuff here. We don't want to run out of time. Let's try to hit some of these financial terms.
Yeah, I was gonna quickly just point out a couple of things on the rent slide here. Base rent is typically calculated on a per square foot basis. Mark and Jeff emphasize the value of engaging a broker in these types of transactions. The brokers will be your best resource when it comes to understanding what is, quote, market in terms of base rent per square foot. They have the best access to that type of data, and that's their job. So really the most value you're going to get out of them, in my opinion, is that type of information. Mark touched on bringing out a tape measure. You know, sometimes you may even be able to get in your lease the right to remeasure the space once you complete the work and are ready to move in. Just be mindful that may or may not work to your benefit. If the usable square footage or rentable square footage is less than you thought, your rent per square, your rent goes down. But if it's more than you thought, it could go up. So just something to be mindful of. It's typical for base rent to go up 2 to 3% per year. And then the other point on this slide are just that big picture, there are really 2 types of leases. There are what's called gross leases, which means there's basically a fixed number that you pay, every month, period. And then there are net leases, which means you pay your base rent and then you pay as additional rent, you know, your pro rata share of the various other costs that we've already discussed, such as, you know, the taxes for the building, the insurance premiums on the policies that cover the building, the common area maintenance costs, etc. Those types of leases are by far the more common type of leases that you see in New York City. So odds are that is what you should probably expect as you go into this process. Anything else, guys, before I flip the slide?
No, I would keep going.
Okay. I think we touched a lot on additional rent, so I'll skip over that. Maybe just worth mentioning percentage rent, just in case there are any retail businesses on the line here. You know, sometimes this is an arrangement that can be reached that makes sense for both the landlord and the tenant, where rent is all or a portion of the rent is based on a percentage of sales at the space. And you really just have to think about what makes the most sense for you economically. You know, some tenants like it because there's downside protection, and other tenants don't like it because they feel that that's their business and not the landlord's business. So just something to think about. Next slide, security deposit. You know, this goes back to what Jeff was discussing early on. When the landlord is vetting you, they're going to look at, you know, your credit history, your company's financial wherewithal, and they're likely going to require a security deposit that takes all of that into consideration. So it could be the size of the security deposit can totally range. You know, your broker is probably another good. This is probably another good point where your broker can be a very helpful resource in guiding you as to whether what the landlord is proposing is quote unquote market. Most commonly, you'll be asked to post cash as security. Sometimes landlords will accept a letter of credit, although that's not very common. Some leases have features where the security deposit will burn down or be returned to you in part over time as the term goes on and there are no issues, etc. Again, just something that we see sometimes, but not always, and is really just market driven. You know, under New York law, it's worth pointing out that the landlords do have an obligation to hold your security in an interest-bearing account, and that interest accrues for your benefit. So at the end of the lease term, assuming you return the space, you know, in room clean condition with no damage, then any interest that would have accrued on that money during that time is actually your property under New York law. So something to be aware of there. Guys, before I jump into guarantees, anything to add on security deposits? Okay.
No, I think you can go ahead, Al.
So just to be aware, you know, lease guarantees tend to be fairly broad in scope, and they do tend to cover all of the tenant's obligations under the lease. You know, one thing that we really sort of advise you to focus your energy on in this negotiation is to make sure that it's a quote good guy guarantee, which basically means that when you vacate and you return the premises in good condition, the guarantee will terminate. It won't sort of linger around forever because obviously you don't want that potential liability to be indefinite. Anything to add on guarantees?
Just to repeat what I think one of you guys said, you know, for the audience, you definitely want to try your best to avoid having to sign any type of broader, more personal guarantee where you personally or, you know, your company or some affiliate is on the hook for all the lease charges, because you know, and I think we're maybe going to have a minute or two to talk about this. You know, many lease terms are going to be written for 5, 10, 15 years, right? There are short-term leases that are certainly available, but sometimes you're looking at a transaction that involves a long-term arrangement, and the nature of the obligations are long-term because you're committing to pay rent in the space for 10 years. And if your business doesn't go as planned after 2 years and you're looking at a default situation, you want to try to avoid being on the hook for 10, in my made up example, being on the hook for 8 years of rent, and rather be instead in a situation where you tried your best to make a go of it, you tried to meet those financial obligations, it didn't work out, and then you're then able to vacate the space, minimize your financial losses. And as Al said, if part of what you ended up signing was one of these good guy guarantees, what that basically means is that when you advise the landlord that you're shutting the business down and moving out of the space, if you turn over the space and give them the keys to the space and leave it in good condition, once you do that, then any personal recourse or responsibility that you'll have will go away, as opposed to a full guarantee where the landlord, if your business fails and you shut down and you have to move out, can then potentially, go after you in court for hundreds of thousands or even millions of dollars of potential liability that, of course, you want to avoid.
Right. Now, we're starting to run out of time, but one doesn't always work this way. But rule of thumb: sometimes the smaller the space, the more the landlord's willing to work with you because they don't want to chase you around to try to collect. If you're dealing with larger space, the more sophisticated landlord and building, they may have lawyers who do this for a living. So just keep in mind who your landlord is. I think we have 3 or 4 minutes left. Do you want to hit a couple of big high points and then see if there are any questions?
Sure. Go ahead, Al.
Yeah, I'm just trying to scan here.
You're looking, by the way, one thing that here, remember I said before, focus really on, especially on the money, what you may be liable for. And there are often multiple charges. If you're late for payment of rent, they may charge you a late fee, but they also might charge you interest on the unpaid amount. So they might get you twice. So take a look at the lease and try to negotiate one or the other, but not both. But that is often the case.
Al, let's take a minute on maintenance obligations and how that works. I think that's a particularly important topic for the audience to know. So in super big picture terms, you just, again, want to be aware of, as part of the lease documentation, there will be one or more provisions that outline both the landlord's responsibility and your responsibility in terms of maintenance of both the building and your individual space. And I think the presumption is that you may be leasing space that is just a part, perhaps a small part of a larger building. And you want to make sure that the landlord has broad and customary obligations to keep the building and the building systems in good condition. And then the landlord, in turn, will have an expectation that you will properly maintain sort of the interior space and sometimes some of your own building systems. For example, if you install a supplemental air conditioning unit because you need it, they may look to you to handle that maintenance. So again, you just want to have an understanding going in of whose responsibility it will be to provide maintenance of certain things and evaluate what the potential cost of that to you would be, and kind of in the general category as well. And this sort of depends in large part on the nature and use of the space, is dealing with cleaning the space. In a typical office lease, very often the landlord will provide cleaning service, baseline type cleaning, and sometimes an office tenant may want to pay extra for more cleaning in a more bespoke or custom type space of maybe the type that you all are looking at. Cleaning may not be included at all, but the landlord may expect that you're going to keep the premises clean. So again, you just want to look at that and understand how that's going to be handled going in, because that's both a practical and to some extent an economic consideration.
And just very quickly, with 2 minutes to go, what Jeff said is important. I think the general rule of thumb in most cases is the building is liable for what's in the wall, the pipes and stuff. You're liable for what's in the four corners of your space. But if you do add-ons, that might change. The other thing is make sure you understand what the building is insuring or what you're insuring. Generally, the building insures the building and the common areas and the hallways and that kind of thing, where you're supposed to maintain insurance for within the space. But sometimes insurance requirements could be pretty extensive. So just make sure before you sign the lease, you know what the landlord's going to require of you to make sure it's within the cost of what you want to spend.
I was going to highlight that. That's always a big one when we represent tenants. It's important. The lease itself will, typically, if it's well drafted, will have a fairly lengthy language about the insurance requirements the landlord expects that you'll have to cover, if you will. And so again, before you sign the lease, you'll want to work with your insurance broker to show that provision to them, to make sure that you can get that coverage and to evaluate the cost of that coverage as, again, an additional cost of occupying and using your space.
And by the way, there's a lot, obviously, we didn't cover. If it's useful to the group, we could always consider coming back for a second follow-up to finish up some of the topics we didn't cover. And I'm going to give a shout out to Gloria Garcia, who told me there's no such thing as a dumb question. Thank you very much. I have 3 kids at home and they might disagree, but I appreciate your confidence.
All right, so how do we go about taking a few questions?
So there's 2 questions. I think we'll start with this one, which will probably have more applicability. Should we, the nonprofit, get an inspection on the building before entering into a contract?
I'll go first if it's okay. Depending on your relationship with the landlord, you might want to start by asking if they've had a recent one that they can share with you. I know that they probably will say no, but I've seen instances where they've said yes. So that might save you a couple of bucks. Now, the next question is, well, if they're not going to share their report with you, are they going to let an inspector come in and perform one on your behalf? I think your inspection rights would have to be reasonable and limited in scope to the space and the portions of the property that will serve your demised premises.
I would look at it 2 ways, Al. One is the disruption factor for your space, and the other is, are they improving part of the building that they could pass part of the cost down to you as a tenant? If, for example, they're replacing the roof and they have the chance to pass the percentage down to you, and you investigate and it looks like they're going to do that work, that's something you should discuss. Also, if your spaces happen to be in a condo or co-op building, you might have your lawyer ask for the minutes of the board of directors, because often any sort of work that's planned going forward, something they talk about, projects they have planned for the next couple of years, that might highlight some of this in their minutes if you get your hands on them.
Yeah, and just lastly, I think I commented on this earlier, I mean, it could be sort of less formal even than a formal inspection report, given the nature and size of the space. But if you, as the prospective tenant and operator and business owner, if you don't have sort of technical and construction knowledge to evaluate the condition of the space, whether there's enough electrical capacity, things like that. If you can find someone who is a friend who knows about construction and building conditions and what have you, and you can get that person literally to walk the space with you and evaluate it for you, they may see things that you wouldn't notice because you don't have that expertise. So as part of your general diligence, yes, I would say if you can do that, even in an informal way, that's a very smart thing to do.
Another thing, it may be worth asking the broker or the landlord if there's a mortgage, they're current in the mortgage, or is there any restructuring or problems with the debt? Because you don't want to move into a space and then find out 3 weeks later the lender is foreclosing and you're getting involved in something you weren't expecting. So you might want to find out. I may not have asked this a few years ago, but every time we go through a downturn, you just want to make sure that the building is hopefully stable, or as stable as possible.
The last question was, what about changes on the removal of broker's fee proposed by the city? If it's implemented, how would that impact a broker's incentive to help a small community-based organization?
So is this like similar to the laws that were enacted as it relates to residential brokers, where originally it was sort of the seller pays and the commissions get split, and now the buyers, it's market driven, but the buyer is ultimately liable for whatever is not paid to their broker. Is that the sort of question there? Like what would happen?
I think so.
If that got passed in the commercial space? Yeah, so the experience, I'm a recent home buyer, so I can speak to the impact that it's had on that side of the process, and I suspect the impact would be similar in the commercial space, which is the market ultimately has dictated how commissions are split, and for the most part, based on the supply and demand dynamics right now, sellers are still offering to pay, and when I say seller, the analogy in the commercial space would be the landlord, are still paying the splitting the fees with the buyer's broker, or would be the tenant's broker here. If it's not, then it becomes up to you to negotiate with your broker up front when you engage them what that deal is going to be. And what I'm seeing a lot of brokers agreeing to, at least on the residential side where these laws are now in full force, is they sort of have a minimum percentage that they're willing to agree to that may be lower than the percentage that they would have gotten if the seller was splitting their commission with them. And they may agree with you that, hey, this is the, let's say it's 2%, whatever the percent is, this is the minimum amount that I need to make this transaction worthwhile for me. So if I get that from the landlord's broker, great, you're off the hook. If I don't, then you just have to pay me, the difference up to that sort of minimum amount. So that's the way that the arrangement has sort of worked itself out from a practical standpoint on the residential side. And I suspect the market would probably react the same way on the commercial side.
I always ask two questions when it comes to brokers. It's common sense. One, who's the broker working for? More importantly, what is the broker's loyalty? Who's it to? Is it to the seller or the landlord, or is it to me as a tenant or a buyer? And two, on the residential side, I was once in a situation where the landlords typically pay the broker, and the broker would say to me, "Don't worry, you're not paying for it." And I look at them and I say, "Oh, I'm paying for it. I'm paying it in the connection with I'm paying a higher price because the landlord is going to turn around and give some of my money to you, but your loyalty is really to the landlord." So I always think about how the broker is getting paid and where the loyalties lie. But those are always in every situation in a real estate deal. I hope we got to enough of this. Thank you, Al and Jeff.
Thank you so much. Really want to thank all of you at Morrison Foerster for doing this wonderful presentation. A reminder to folks listening in that we will be sharing the presentation and also uploading a copy of this session on Cultural Affairs YouTube channel and the NYC Create in Place website. Thank you all again and have a great week.